The motion to dismiss in the Karen Reed case was argued today. And as we have come to expect, it started off with some fireworks. Before we even got to the hearing, though, we were all waiting on the defense to finish their arguments in federal court as it relates to the double jeopardy appeal, which is currently in the federal courts. So eventually they made their way back to the state court and they began the motion. Well, right away, Judge Cannoni confronted Alan Jackson about one of the arguments that he made in his motion to dismiss. So his motion to dismiss was based on three different reasons. Number one was the fact that the Sallyport videos keep seeming to appear out of nowhere, produced way after trial, showing new things, showing exculpatory information like Brian Higgins on the phone at 1:30 in the morning. And there was also an argument about Jennifer McCabe. Now, for some reason, Alan Jackson did not talk at all about what happened with Jennifer McCabe. And I think the one most important part that he could have argued as it relates to the Jennifer McCabe situation is the fact that Lieutenant Tully did not write anything about that meeting with Jennifer McCabe until 20 days later and didn't turn it over to the defense for like 24 days later. So there's some questions there about why was Lieutenant Tully acting that way. I think he could have addressed this issue. For some reason, he didn't. He really focused mostly on some of the jury tampering arguments and then mostly the Sallyport video. Okay, but that was just a question in my mind. I don't know why he completely left the whole Jennifer McCabe situation with Lieutenant Tully writing the report 20 days later and turning it over after everything. I don't know why he left that alone. I think he could have argued it. But anyway, so Judge Cannoni right away confronts him about his allegations about the jury tampering. And that was the following. Remember, any time now that Alan Jackson is going to say anything and represent anything in his papers or in oral argument or on sidebar, Judge Cannoni is going to be very careful with him because we know that she's already considering to revoke his pro hoc vice status because of some misrepresentations that he made at sidebar and maybe in the pleadings. So it's going to be a very sensitive issue. So right away, she's saying, look, you signed, you said that everything that you're writing in this motion is with good faith. So how can you in good faith say that Lieutenant Fanning had any sort of control or access to the jury when you know that's not true? It's not true. So Alan Jackson responded, and apparently we just have to know the backstory a little bit about what happened. So I didn't really hear all the details before, but today we're getting some more bits and pieces about what happened, so I'm going to share them with you. Apparently, there was a juror who, at a supposed private location, was having some sort of conversations and was recorded, it seems like. She was recorded in some way, and that person who recorded that juror decided that what this juror was talking about was inappropriate, was improper, and this unidentified, unnamed individual reported it to Lieutenant Fanning. So one of the things that Alan Jackson concentrated on is how did this person know that this is a juror in the Karen Reed case, and how does he know that Lieutenant Fanning is the one to report things to? Okay, so some definitely some questions there. Nevertheless, he reports this to Lieutenant Fanning. Fanning reports it to a court officer. The court officer reports it to the judge, and then there's a sidebar right before closing arguments. At that sidebar, that's when they were discussing about what happened with this juror. And at the sidebar, one of the prosecutors, McLaughlin, said to Alan Jackson that Lieutenant Fanning is the commander of extensive security operations in this case, which Alan Jackson says, look, a reasonable inference is that if you are the commander of the extensive security operations in this case, that would include, obviously, the jury. So that could give you control in some level and some sort of access to the jury. If you're the commander, after all, then you should be able to have access to anything and everything. So therefore, it's a reasonable inference that he did have some sort of control or access, or we should at least be able to question him in an evidentiary hearing and get to the bottom of exactly what happened. We don't even know who this person was, this unidentified person. And then what resulted was that the juror was called in. This nobody saw. I didn't see this unless you were in the courtroom. Maybe in the courtroom also they threw everybody out. I don't know. But they called the juror in, and the judge can only question the juror. The juror seems to have denied doing anything improper and inappropriate, and nevertheless, the juror was dismissed from the case. And this was a juror that the defense felt very strongly was pro-defense. So that's part of the reason that why is this person dismissed? We need to get to more of the bottom of what exactly happened here, especially who this unnamed, unidentified individual is who's reporting this, which caused the juror to get dismissed from the case. So we said, and Alan Jackson said, we at the time at sidebar, we said we want to have some more evidence about this. We want to find out exactly what happened. And the judge said, no, we're not doing it. So therefore, we feel that could be a basis for that her constitutional rights were not being protected at that time. After all this, Judge Cannoni still said to Alan Jackson that she's not satisfied with his answer. Okay, so again, anytime you see any sort of friction there's going to be some sensitivity because she's already considering that maybe he's not acting with some sort of candor to the court. So just another instance that she may hang her hat on in revoking his pro hoc vice if she ends up doing that. And again, like I told you from the beginning, it's a very sensitive balancing act to able to suspend or revoke his pro hoc vice status because of the Sixth Amendment. Anyway, let's move on. So Jackson moved on with his argument, and he said that, look, a lot of the Commonwealth's arguments back is that this is all the police fault and has nothing to do with the prosecutors. The prosecutors didn't know. They didn't know about the Sally Port video. And in fact, they had no reason to believe that it was even important in this case, which we'll get to later. But a big crux of the argument from Brennan was, in his papers at least, was that it's not the fault of the prosecutors. It's the fault of the police. And Alan Jackson's response was, it doesn't matter because you guys are all together. It's not the prosecutor we have an issue with. We have an issue with the Commonwealth. The Commonwealth is all encompassing. It includes the police, it includes the detectives, it includes the prosecutors. So you can't just say, well, I didn't know about it. Well, it doesn't matter if somebody else knew about it and they're the detectives on the case, then that's included in the Commonwealth. And therefore, if there's a Brady violation, it attaches to all of you. Sorry, it's not your fault. Nothing you can do about it. That's number one. Now, number two, I think there could have been a stronger argument from Alan Jackson that even if the prosecutors did not know about it, there's still a requirement for them to make a reasonable inquiry. They do have to make a reasonable inquiry into any sort of exculpatory evidence that's possible to come out. Any sort of Brady material, they do have to make a reasonable inquiry into this stuff, which does not seem to have happened until something like February of 2024, April of 2024. So that's when the reasonable inquiry was done. And why did they wait until April 2024? So that's a part of the argument that he makes. Now, Alan Jackson said that he received just recently, again, they keep receiving some more discovery. He said that he received from Buchanan a report which shows that in May of 2024 is when he received the video of the exterior Sally Port. Now, remember, we saw the interior of the Sally Port video. That's the inverted video. But there's also some videos of the exterior Sally Port, which they never received. And Buchanan is saying that he did receive them in May of 2024. But they did not get those videos until October of 2024. And then again, January of 2025. So again, that must have been intentional. Why would they not turn that over? Now, another argument that he has to address is the fact that these exterior Sally Port videos are not clear. They're grainy, they're jumpy, they're moving. You can't really see anything from these exterior Sally Port videos. So if you can imagine a police station not having good security videos. All right. But anyway, so he's saying that, well, you may argue that why is that exculpatory then? You know, there's nothing the videos would show anyway. What would these videos help you in the first trial if you can't see anything anyway? Well, even if the actual material of the video is not clear and you can't see, let's say, Karen Reed's taillight, but you could still show this as evidence. You can still argue this to the jury that, look, all these videos that they're turning over are mysteriously missing a very, very important, crucial part of this case, which would have solved the case or would have definitely helped a lot, which is that you would have been able to see the taillight. And just by the fact that all these videos that are produced seem to be very unclear and grainy, well, that itself is an argument. That itself is exculpatory. So that's part of the argument that he made as well. Now, he said that all these photographs that Hank Brennan was talking about in his opposition, because one of the things that Hank Brennan argued in the papers was that, you know, we provided so many photographs of the Karen Reed's Lexus and we showed them, we gave them so much, we gave them witness statements about what it looked like. It doesn't matter because those photographs, Alan Jackson wanted to point out, were taken on February, not January 29, 2022, or even January 30th. Those photographs are taken later. So those photographs aren't going to help us solve this case. We need to know what that taillight looked like at the Sally Port. Now, he also had to address the argument that Brennan made with respect to the CERT team being at 34 Fairview before there's any sort of opportunity for anybody to plant the taillight pieces there. So he argued that it's not really accurate because all you know from the CERT report is that when they showed up. Doesn't say when they began their search. They could have been all sitting in their warm cars. And he said that the last person to show up, the last team member from the CERT team, showed up at 5:41. And the first piece was discovered at 5:45, which would still give plenty of time, even if the car was at the Sally Port at 5:30, would still give plenty of time for you to plant some of the pieces. So that was in response to the CERT argument that Brennan made. Now, he also had to point out a lot of Trooper Proctor's conduct in this case. Because again, anything that Trooper Proctor does that violates Brady attaches to the entire Commonwealth, the entire prosecution team. So he said that there's 9 different documents which state the wrong time. And you're gonna chalk that up to just a mistake. 9 documents. What's the chances? What are the chances that somebody would, and some of them are under oath, that you're just going to make the wrong time? For example, when you retrieved the Lexus, which is an important time in this case, where Proctor wrote he retrieved it at 5:30, which really he retrieved it at like 4:12. Now, again, he argued about this other argument that Brennan made. And that other argument that Brennan made was the fact that in the request to preserve the evidence, they never requested specifically the Sallyport video. This motion that Yannetti filed in the district court level, Stoughton, however you say it, and then later again in front of Judge Cannoni, it says they're all physical evidence. So Alan Jackson is saying, look, let's not play word games here and try to put commas in different places. And what does all physical evidence mean? Does all physical evidence mean only all physical evidence at the crime scene? You guys know what we want. And we don't really know the case too well, where we're trying to make a request to preserve everything that's integral to the case. So when we say all physical evidence, give me a break that you think that it means, only all physical evidence that are at the crime scene. Of course, we mean all physical evidence that are related to this case. So that's number one. Now, I think he could have made a different argument also. I think he should have made this argument, and that is that even without any formal request, even without any sort of motion or order, the prosecution is required under Massachusetts law to preserve any sort of Brady material or any sort of exculpatory evidence. And that was not done. So that is what also, even if you want to read in all physical evidence means all physical evidence at the crime scene, it doesn't matter what we say. We don't have to make any sort of formal or informal request for you to do your job, which is to preserve all exculpatory evidence. So that's another, I think, argument that he could have made, which I think he could have made a little stronger, which I don't think he really made. Also, he said that it's interesting that Morrissey actually referred to the crime scene because he was talking about when Proctor reported to the crime scene, which Proctor actually reported to the Canton Police Department. And that's how he tried to correct his statement. And so therefore, you can't have it both ways. If the Canton Police Department is the crime scene, so then how can you get up here and argue that when we say all videos or all physical evidence at the crime scene, which they didn't, by the way, but even if you want to make that argument, so then that would include the Canton Police Department according to your own Morrissey. So that's what that. Now, he moved on, which is another interesting argument they made. He said, what's this idea that Brennan was referring to in his papers? He calls the trial prosecutor didn't know. What do you mean the trial prosecutor didn't know about the evidence? Why don't you say the person? Say the person's name. There's only 2 of them, Adam Lally and McLaughlin, right? So then just say I think it's Sarah McLaughlin, but just say the names, right? So why are you trying to like couch it with some secrecy? The trial prosecutor didn't know about it. Just say who it is. And that's exactly the point here. The point of Alan Jackson is making is that we don't know any of this. Who did what? Why don't you say who did what? That's what we need to get to the bottom of. That's why we need an evidentiary hearing in this case. He also said that there was an affidavit that was signed by all of the prosecutors in this case, which is interesting because usually one person signs an affidavit. He said he's never seen this before, where you have 3 attorneys signed on the same affidavit. You ever find any time when you have 3 people signed on one affidavit? Which statement is attributed to which person? It's vague and ambiguous. So he said that's what happened in this case also. Again, another indication that we need to know what happened here. Now, another issue, which he spoke about, which I also talked about, is that the argument that Brennan is making is that Adam Lally didn't know about any of this until February 2024, when Michael Proctor testified in the federal grand jury proceeding, and he said that he reviewed all the videos. That's when all of a sudden Adam Lally realized that there are some videos available here. And in Brennan's papers, he said that he promptly turned them over in April of 2024. So again, we're talking about Adam Lally. So Adam Lally knew about this in February of 2024, and he promptly turned them over in April of 2024. Promptly. From February, March, April. So it took 3 months about. I don't know exact days here, but from February to April to actually turn over the videos. That's promptly promptly turning it over, and you turn it over right before trial. I mean, what's the chances that this is just a mistake and this was not intentional to ambush us, right? To ambush us at the last minute to get these videos over, and then some videos even in the middle of trial. So he also talked about how Buchanan testified first that with the inverted video, and they tried to trick the jury by trying to convince them that this is really the correct way that you look at the video and everything's accurate, and really it's inverted. And this comes back to the argument that if Brennan makes the argument that really all the videos were always inverted. Well, if all the videos were always inverted, well, then how can you get up here and tell the jury that this is accurate? If you know it's inverted, right? He just used his own argument against him. Brennan, you're telling us all the videos are always recorded. This is the way that it was set up. Everybody knows that, I guess, or maybe this is the first time. But the idea is that, yeah, they're always inverted. Well, if they're always inverted, then why should you represent to the jury that this is actually an accurate depiction of what was going on there when really it's inverted? And we had to point that out to the jury. Again, it looks like there's something much more intentional and egregious going on here. He also said that in his direct examination, he said very clearly, well, yeah, that's Trooper Proctor in that video. And you can see he's not going anywhere near the right rear tail light. And then when we were on cross-examination and we pointed out that the video is inverted and that person, whoever it is by the right rear tail light. And all of a sudden he's like, well, I'm not sure if that's Proctor anymore. So again, looks like they're not being so honest about this. So then Alan Jackson argued about the idea of prejudice. And this is something that Judge Cannoni was asking about. Now, obviously, it's prejudicial if you don't have exculpatory evidence to provide to the jury, right? That's pretty clear. But what Alan Jackson wanted to argue here is also the fact that we don't even have to prove actual prejudice. Prejudice is presumed. If there is Brady material that was not turned over, we don't have to prove that it would have been prejudicial. All we have to prove is that there was Brady material that was exculpatory that was not turned over, and then the court has to presume that it's prejudicial. Now, even without that, he showed that it would be prejudicial. Okay. Then he also showed, I think it was Chief Rafferty, where she was turning over. I think it was Chief Rafferty was turning over some of the video, and she says something about it being like, she wrote like, LOL, it's not inverted or something. And he said, like, this is a serious case going on here, and you have the chief saying, LOL, it's not inverted, like making a joke about this whole situation, which is not a good look either. All right. Well, then he said that in April of 2024, the prosecutor, Adam Lally, requested all videos. Okay, so now again, let's think about intention here. Here now, you got to April 2024. Let's assume everyone's just didn't know about it. Let's say the prosecutor didn't know about it, and now you do find out about it. And you request all of the videos to be turned over, which means as a prosecutor, you're requesting everyone to now look through your files, make sure that you turn over all the videos. So all videos were still not turned over until after the trial, October or January of 2025. They're discovering more videos. Is that a mistake? Is that intentional? Certainly looks like it. Certainly seems like it. Certainly should raise enough questions that you should want an evidentiary hearing to find out about this. So again, another point for Jackson. Then he said that he got a report from this past Friday. He just got a report from this Sergeant DiGiapietro, who everyone was talking about today in the hearing. And in this report, it says that Proctor requested the videos of the Sallyport exterior video. Exterior. Now remember, the exterior is the one that's been just recently turned over. The exterior video in February of 2022. So this was requested in February 2022, these exterior videos, which Proctor knew was important for this case. And it was so long that Proctor had to break it down into 6-hour segments in order to download it. And he downloaded every single part of that video. And it was never turned over. So Alan Jackson said, this is very clearly an attempt to ambush us, to hold our hands behind our back. Now, when I was watching this, I was thinking, it would be a great way to argue that, you borrow what Hank Brennan argued. Remember how Hank Brennan argued about the ARC experts, that they didn't turn over these emails about that and the invoice. And he said, this isn't trial by ambush. This is being duped. And I think that would have been a good time for Alan Jackson to say, if I can borrow Mr. Brennan's statement here, phraseology, this isn't being ambushed. This is being duped. So I was waiting for that. I would have liked to hear that. But anyway, moving on. So he says that Proctor lied on the stand. He pointed that out. And then he pointed out the fact that Brennan is arguing that they were equally aggrieved. Right? Your defense, you're arguing that you're aggrieved by this because it's Brady material. It could have shown that the taillight wasn't as smashed to smithereens as it looked like later. And but we were also aggrieved because if the Sallyport video would have shown the taillight smash at smithereens, it would have helped our case a lot. Well, Jackson said, so you're acknowledging that we're aggrieved. Isn't that what you just did? You're just saying that you're also aggrieved. So you're saying, okay, don't complain. We're also aggrieved. Okay, well, that's the end of it. That's exactly the point. You feel you're aggrieved. Fine. You're aggrieved too, but we're aggrieved. And you're agreeing with that we're aggrieved. You're agreeing that this is exculpatory. You're agreeing that this is Brady material. So right away that you're acknowledging that the importance of this, and you're acknowledging that it's Brady material. Definitely potentially Brady material. And therefore, he argued that dismissal is warranted because one of the reasons under the case law that dismissal is warranted is to prevent repetition. If you have any reason to believe that this type of conduct is going to repeat itself, that's an indication that maybe you should dismiss this case as the judge. So this is part of the argument that Alan Jackson was making, was that in order to prevent the repetition, which we keep finding, how many more videos are we going to get before the end of the third trial in this case? Who knows? But we keep seeing the same thing repeating itself. Well, that's a reason, that's an indication that dismissal is appropriate. It's intentional, it's egregious, it rises to misconduct, so it's a Brady violation, it's a Rule 14 violation, and it's also misconduct. This is all intentional. This was not done. Proctor wasn't just making a mistake. This was intentional. Okay. Then Brennan got up, and Brennan went through the different timelines, and he kept arguing that the prosecutors had no idea about it. Okay, fine. The prosecutors had no idea about it. But then he said that even Trooper Proctor, there's no evidence at all that any of this was intentional. There's no evidence. Now, the point here is that it looks intentional. There's definitely some reasonable inferences that this could be intentional, and especially when you think about Proctor's conduct in this case in general. So if you have a detective, a leading detective, who through the entire case, you can't point to anything that he did that was suspect at all. And then you have one thing, and you can argue, you know what? Why should we assume that this police officer, who we have no reason to believe or suspect that did anything wrong in this case, why would we automatically assume that this was intentional? But when you have a situation with Proctor, where there's a lot of things that you can point to, which for the very conduct that he took in this case, he is going through administrative proceedings, which could result in his suspension. So that would right away say, you know what, maybe we shouldn't just give him the benefit of the doubt anymore. Maybe there's something a little bit more. Maybe we shouldn't just trust Hank Brennan that this was all just one big mistake. Maybe we should actually have more of an evidentiary hearing, more of a digging to really see what's going on, because we already have some suspect conduct by this person who is right now going through administrative proceedings to see whether he's going to keep his job or not. Okay, so, you know, should we just believe Hank Brennan that this is all just one big mistake? And that's essentially what his argument was. He also argued that there was no order, there was no request, there was no motion. And as we spoke about, I think the strong argument to that Alan Jackson could have made was it's not necessary for there to be a motion. It's not necessary for there to be a formal request or an informal request. And again, Jackson's point is also well taken that it doesn't matter if everybody here is on the same team. You all realize how it's important. The detectives definitely realize that this video is important, and they should have turned it over right away. Now, he also said that there is no evidence at all that any videotape was tampered with. There's no evidence of that. How are we supposed to assume that, right? You got one clear video of the inside of the Sallyport. The exterior of the Sallyport is grainy. And then what Brennan did is that he showed that the inverted video, actually, they're showing a clip from an inverted video earlier on. So not just the January 29th video, they showed some video of a different date in the same Sallyport, and it was inverted. So he said, you see that this is just the way. This is what he said in his papers. He said that this is just the way that the camera settings were. They were just inverted. And he showed a clip of a different day where it was inverted. Now, one of the things that Alan Jackson argued is that well, if it was inverted, everybody knew about that this was inverted. Well, then why would you present Buchanan and Adam Lally and go through this whole charade about how everything looks accurate, and go through this whole game that, oh yeah, it's all accurate, when it's really, you know that it's inverted. Well, maybe you didn't know that it's inverted. I guess Brennan would argue they didn't know it was inverted, but this is just the way that it's always recorded. Now, also something that Jackson pointed out is that even in the two videos, the inverted videos, this inverted video that Brennan played for the court today, actually there was the time was running on top, the digital numbers were on top, and actually the inverted video in trial was the numbers on the bottom. So again, it looks like there's some more tampering with this video also. So that's another point. But this is what Brennan argued, that there's no evidence at all that the videotape was tampered with. But that's exactly the point. The point is that we don't know. We don't know the answers to these questions. And when you're asking for an evidentiary hearing, which is what I explained before, when you're asking for an evidentiary hearing, the point is that I don't have all the evidence in front of me. That's why I need an evidentiary hearing. You can't argue that there's no reason, no basis for an evidentiary hearing because there's no evidence proving your point. That's the point. That's why I need an evidentiary hearing. The whole point of getting an evidentiary hearing is when you have enough questions, enough facts to show the court that there is some uncertainty here that we need to clear up. We need to get the facts straight in this case. And the only way we're going to be able to do that is if we have an evidentiary hearing. That's the point, to provide evidence. That's what an evidentiary hearing is. So the fact that Brendan's saying, well, there's no evidence that that the videotape was tampered with. Okay, well, let's get some more people on the stand. Let's figure this all out. That's exactly the point. But we brought up enough issues in front of the court for the court to say we need an evidentiary hearing. That's the point. Okay, anyway, moving on. He also argued that none of this information is exculpatory. You know why? And he showed some of the videos. So he showed the videos of the Ring camera at John O'Keefe's house, where Karen Reed is backing out when she nudged into the traverse, and then pulled out, and he stopped it, and you see that there's already a piece missing. And then he also showed some other videos showing that the piece is missing, the well checkup, and these different things that the taillight was already, you could already see that the taillight piece was missing. And then on top of that, he said that in Gretchen Voss's interview with Karen Reed herself said that a few pieces of her taillight were missing. That's what he quoted. A few pieces of the taillight was missing. And there was a bulb showing, and she dropped off some of those pieces in John's driveway. That's what he quoted from Gretchen Voss's interview. And in response to this, Alan Jackson said that she agrees that there was a piece missing. Maybe that one piece turned into a few pieces, but we all agree that there was a piece missing. It was cracked. There was a piece missing, but not the extent that we see later in the pictures that the Commonwealth produces. That's the whole question. The whole question here is that we know that there was some sort of piece that was missing. Question is, how much was missing? Was it just one piece that showed a little black hole? Or was it one piece that you can see the bulb from? Or was it the whole side that was knocked off? And some people would argue that some of those videos show that there's actually a piece on the side which reflected red, so that you could see that some of the taillight was actually still intact. All right. And then he moved on to the jury tampering argument, Hank Brennan, and he went on to this whole thing about you can't attack juries, and we were not giving any confidence to the people to come in here and make these type of arguments. He went on a whole argument about you can't even suggest these type of arguments unless you have really, really, really solid evidence, which Alan Jackson doesn't have. So he knew that Judge Cannone did not like his argument about jury tampering, so therefore Hank Brennan kind of capitalized on that, and he went on a whole tirade about how important it is to not attack the jury system and not lose the confidence of the public over the jury system. Okay, and then he also quoted Alan Jackson in the interview that he gave at prime time, talking about the jurors. Okay, fine. So that was how he ended. And Jackson's response, and then then also something that he said, Brennan also argued, is that this Lieutenant Fanning, he's just pure, and you can't even attack his credibility. He's so well known, and everybody knows him to be such a wonderful guy, and he's just great. And how can you even think of getting up here and attacking this man's integrity? So he went on, and he did a pretty interesting presentation. He was like, I'll give you a number of facts. Fact one, that Lieutenant Fanning is a decorated officer. He's just one of the best. And fact two, and fact three, and fact four. And it was very impressive. And then Alan Jackson got up and he said, all those facts that Henry Brennan just said, how do we know those facts are true? How do we know anything about those facts? Did Hank Brennan have an interview with Fanning to find that out? Who did he talk to find all that stuff out? That's the point. The point is that we don't know. He didn't attach anything like that to his response. He didn't give us any exhibits about any sort of interviews that he had with Lieutenant Fanning. But that's the whole point. The point is that we can't just take your word for it to tell us that, oh yeah, don't worry about Lieutenant Fanning, don't worry about Michael Proctor, don't worry about anything else. Nothing's exculpatory. Just take my word for it. That's the whole point. We don't want to take anybody's word for it. We have enough questionable activities in this case that we need to have an evidentiary hearing. And that's essentially what Jackson's response was, that, look, all these questions that we don't really have answers to still are relevant. One of the things that Brennan brought up was that, we don't always retain and download videos from the Sally port. In every single case, you think we download and save videos from the Sally port? How are we even supposed to know in this case that the videos on the Sally port are even important? How are we supposed to know that? And the obvious answer is that, yeah, well, if you're investigating a bar fight, like Alan Jackson said, if you're investigating a bar fight, well, then of course you're not going to need the Sally port video. But when here, in this case, where the allegations are that the Lexus was the murder weapon and it's sitting in the Sally port, don't you think that would be important to save that video? And in fact, Proctor realized that, which is why he downloaded it. So don't pretend that there's no importance to the Sally port video, and how are you supposed to even know as a prosecutor that the Sally port video is important to preserve and make requests for and make a reasonable inquiry for, which very clearly was not done in this case until 2024. Of course you need to make the inquiry. Of course you need to understand that the Sally port video is important. So that's exactly why you should have made sure that, since that is what you think the murder weapon is, that those videos were preserved and were proper. Everything done with them was proper and forensically sound and everything, all that good stuff. Okay. So that's essentially what happened today. We will see what Judge Cannoni decides to do with this. Maybe if she's going to deny the motion outright, or if she's going to order an evidentiary hearing. Like I said from the beginning when I was reviewing this, I believe that an evidentiary hearing must happen. That's the correct action in this case, to get all these things on the record, see what was going on, get some better answers to the questions, not just trust Hank Brennan, especially when you have Michael Proctor, who is already shown some of his true colors in this case, where you can't just chalk anything up to mistake at this point. So there has to be, I think, at least an evidentiary hearing in this case, so just to figure all this stuff out. And if they answer the questions to the satisfaction of the judge, okay, great, deny the motion and we'll move on to trial. But I think at least she should order an evidentiary hearing. So we will see eventually what she does. So that's going to be it for now. If you haven't yet, please subscribe, like, and we will see you next time.